I now have the pleasure of calling our last and final witness, last but not least, Mr. Stephen Watt.
Thank you, Commissioners, for giving me the opportunity to speak this afternoon. And I'd also like to extend my thanks to Catherine and the members of the Stop Torture Now coalition, who are the creators of this, this event today. You've really been an inspiration to me in my work since we first started working together back in 2005, so thank you. So I'm speaking about legal redress in US courts. Since 2002, I've represented men who were unlawfully rendered, arbitrarily detained, interrogated and tortured by the government of the United States, its agents and contractors at Guantanamo Bay, and overseas prisons once run by the CIA and by foreign governments. I've been counsel in numerous federal court cases challenging these unlawful policies and practices, including 4 federal court cases brought on behalf of 10 men who were victims and survivors of the CIA's rendition, detention, and interrogation program, which I and other advocates know more appropriately as the CIA torture program. My testimony today will focus on these 4 cases and what they reveal about the prospect of civil legal redress for victims and survivors of US extraordinary rendition and torture in US courts. So since 2004, 4 major lawsuits challenging the CIA's torture program, including its rendition component, have been filed in US courts. However, until this year's successful settlement reached in Salim versus Mitchell, one of the cases, none of these cases had resulted in meaningful redress for victims and survivors of the program. In the 3 lawsuits that preceded Salim, victims and survivors' attempts to secure redress all met similar fates. US courts summarily dismissed these cases based on government claims of immunity or state secrets, without any consideration of whether the men were in fact forcibly disappeared and tortured. The first legal challenge was brought in federal court in New York in 2004. And it was brought on behalf of a Canadian citizen. His name is Meher Arar. He was transiting through JFK Airport from a family holiday back to his home in Canada. He was detained by immigration officials. He was interrogated and then threatened with rendition to Syria, a country that he'd left when he was 17 years of age. He was detained for a further 13 days and then secretly flown first to Jordan and then to Syria, where he was brutally tortured for the best part of a year. He was eventually returned to his home thanks to the intervention of the Canadian government. We filed suit in New York federal court, as I say, in 2004 for violations of the US Constitution and a US statute, the Torture Victim Protection Act, that prohibits anyone from torturing an individual under color of foreign law. The following year, in 2005, we filed the second case on behalf of German citizen Khaled El Masri. Many of you here will be familiar with his story. Khaled was in Macedonia in 2003. He was detained by Macedonian agents. He was brutally interrogated for 23 days incommunicado. All his requests for a lawyer were denied him. He was told he was going to be handed back to the German government, but instead he was handed over to the exclusive custody and control of the CIA. A black renditions team stripped him of his clothing. They beat him and they drugged him and they loaded him onto a plane and flew him halfway around the world to a secret CIA prison where he was held for a further 5 months and tortured. He was released eventually, but not back to his home in Germany. he was deposited on a hilltop in Albania and eventually found his own way home. We filed suit in the Eastern District of Virginia in 2005. We filed suit against then director of the CIA, George Tenet, and a number of aviation corporations that aided and abetted the CIA in Khalid's rendition and torture, one of them being Aero Contractors Limited. The suit was brought under the US Constitution and also the Alien Tort Statute. Shortly after the Supreme Court declined to review the lower court's dismissal of Khalid's case in 2007, we filed a third federal lawsuit challenging the extraordinary rendition of 5 men, Binyam Mohammed and Bishar al-Rawi, both UK citizens, Ahmed Agiza, a Swedish refugee, he was originally from Egypt, Mohammed Bashmila, a Yemeni, and someone who you heard about yesterday, Abu El Qasim Brutel, an Italian citizen. We sued Jeppesen Dataplan Limited, which was a company that investigators had uncovered was involved in providing flight logistical support services to the CIA in its rendition program. It was basically taking men from point A to point B where they were tortured. We brought suit only against Jeppesen Dataplan this time under the Alien Tort Statute, alleging claims of forced disappearance and torture. Now, the factual allegations in these 3 cases are gruesome, and if one accepts their truth, the perpetrators of these crimes should have been held accountable. Torture and cruel, inhuman, and degrading treatment or punishment and other human rights violations committed in the CIA's program have long been criminalized in the United States, but they also give rise to civil causes of action against perpetrators, including those who aid and abet or are otherwise complicit in them. But instead, in all 3 cases, the Bush and Obama administrations intervened to shut them down at the very outset, claiming that adjudication of the plaintiff's claims would be harmful to national security interests or interfere with US foreign policy. US courts largely acceded to the government's claims. Courts, in effect, held that if US officials and its contractors did torture, there's no remedy in a US court because of the national security and foreign policy concerns that might be implicated. Now, at the heart of the US court's dismissals of these 3 cases was the fact that the United States had never officially confirmed or denied its role in the unlawful rendition, detention, or torture of the plaintiffs. And indeed, at the time that the cases were filed, the United States hadn't even officially acknowledged the existence of any component of the CIA's torture program. This all changed, however, in December of 2004, following the public release of the executive summary of the Senate Select Committee on Intelligence Study into the CIA's detention and interrogation program, but only insofar as, as it related to the detention and interrogation aspects, not the rendition component. The Senate Torture Report does not examine all components of the CIA torture program. In particular, it doesn't examine CIA renditions. Although the report acknowledges that the CIA carried out renditions, it does not provide details of that component of the program, such as the names of the persons who were rendered, or the perpetrators or others that participated in the rendition process, including government contractors. The US government then has neither confirmed nor denied these key facts, and they remain largely classified. But the report does name the architects of the CIA torture program. It confirms the role of US officials in authorizing torture and covering it up and misleading Congress in the process. It details the detention and interrogation program's design, development, and implementation. And most importantly, it lists the names of 119 men who were detained and interrogated by the CIA and the torture methods that were used on them while they were held in CIA custody. With the publication of the report, none of these facts and others in it are now classified. And because the United States has officially confirmed and admitted them, they could not be the subject of a proper claim of state secrets. The report helped change the legal landscape for torture accountability in the United States for some victims and survivors of the US detention and interrogation practices. The report's public release allowed us to file a fourth case against two key architects of the CIA's torture program, US psychologists James Mitchell and John Bruce Jessen. They're identified in the report by code names, but those code names were subsequently declassified in the course of the litigation. We brought suit on behalf of two survivors of the program, Suleiman Abdallah Salim and Mohammed Ahmed Bensoud, and the family of Gul Rahman, who froze to death in a secret CIA prison in November 2002. The family was represented by Ubaidullah, Gul Rahman's nephew. The three men alleged that they were tortured and experimented on by CIA officials using methods devised, developed, and implemented by Mitchell and Jessen. All three men are named in the report, and that's significant. Now, as the government bent over backwards to keep these three men hidden from the American public, let's bring them into the picture here in Raleigh. So if we could maybe, Jess, how do I do this? This one? Oh. So this is Suleiman. Suleiman is a fisherman from Zanzibar. He lives there. He was rendered from Kenya to a black site in Afghanistan in 2003, and he was held and brutally tortured there for some 6 weeks. Nope. That's me. This is Mohammed. Mohammed is a Libyan citizen. You'll have heard about Mohammed from Laura Pitter yesterday. Mohammed was rendered from Pakistan to the same prison as Suleiman in Afghanistan in 2004. And he was held there for a year and brutally tortured before he was released. Not to his home in Libya, or back to Libya, where he had fled when he was a student because he was opposed to the Gaddafi regime. And finally, this is Gul Rahman. Gul Rahman is, or was, an Afghan citizen. He was rendered from Pakistan to the same prison as Suleiman and Mohammed. In 2002, he was one of the first detainees in the program. He was, and it's recorded in the Senate report, he was killed while he was in that prison. And to add insult to injury, the family are still waiting for the return of his body. They have never even been notified of his death. So that's the three heroes of the Salim litigation. They're really, I haven't met Gul Rahman obviously, but Suleiman and Mohammed are truly incredible people. And they had to be to go through this litigation. The Senate report not only confirmed the names of individuals who were tortured, it confirmed that Mitchell and Jessen were responsible for designing the torture methods used by the CIA on Suleiman, Mohammed, and Gul Rahman, and 36 other prisoners. The report and other government documents produced in the course of the litigation also confirm that Mitchell and Jessen helped the CIA to develop and implement the CIA program. They confirm also that Mitchell and Jessen used their tortures on specific detainees and experimented on them and evaluated the effectiveness, so-called effectiveness, of their methods that they had designed and used on CIA detainees. And for their assistance, and that involved planning, aiding and abetting, and conspiring in torture, human experimentation, and war crimes, Mitchell and Jessen and the company they formed in 2005 to run the entire CIA torture program, including its rendition operation, were paid $81 million. This fact is also confirmed in the Senate torture report. In the course of the litigation, we deposed Mitchell and Jessen about their roles in the program, as well as then head of the CIA Counterterrorism Center, Jose Rodriguez, and acting general counsel for the CIA, John Rizzo. All of this testimony was recorded under oath, and it's now publicly available. It was the first time ever that architects of the CIA torture program, including senior CIA officials who authorized torture, had to answer questions by civilian attorneys about their roles in the torture program, about the crimes that they had committed, and our clients' torture specifically. The legal battle was really hard fought. It came at great cost to Suleiman, Mohammed, and Obaidullah, and other members of Gul Rahman's family, as they were compelled by the demands of the litigation to relive their traumas on a sometimes daily basis over a 2-year-long period. It had effects on lawyers too. Suleiman and Mohammed had to undergo invasive psychological and medical testing by doctors for the defendants, and all three had to undergo depositions by defendants' attorneys. This was, as you can imagine, hugely difficult for them, both emotionally and physically. For instance, to sit for depositions and to undergo these invasive medical examinations, they had to travel to South Africa, Dominica twice, and the United States. As Suleiman described it, sitting for deposition was like being interrogated by his torturers all over again. You can watch, and I would recommend the commissioners to watch the video testimony to see how traumatizing deposition process is. As you can imagine, the financial costs of the litigation, attorney fees and costs, were enormous. But in large part due to pretrial decisions in the case, the defendants asked our clients to settle it out of court before trial, which was scheduled to begin on September 5th. After many long hours of negotiations between us, Suleiman, Mohammed, and Obaidullah, and lawyers for the defendants, we finally settled the case in August this year. The terms of that settlement are confidential. But the settlement of this case is landmark. It marks the first case in a 15-year-long effort by advocates to hold some US torturers to account and to provide meaningful redress to 3 victims and survivors of the CIA's torture program. Now, if I could just conclude with a few remarks and perhaps recommendations. Salim and the Senate Torture Report, they have opened the door to legal redress in US courts for some victims and survivors of the CIA torture program. But that door remains shut to others, including those who were not held in exclusive CIA custody, but rendered to interrogation and torture by foreign governments. For these men, US courts offer little scope for meaningful redress. For them, we still have a very long way to go. And US courts, for now, I believe, will offer them no prospects of success in the courtroom, at least. To end the impunity, the United States needs to address torture accountability in a more holistic, comprehensive way. And in particular, the United States needs to provide greater transparency on the rendition component of the CIA torture program. We need the United States government to commit to a comprehensive investigation into US renditions, like the one that the Senate Select Committee on Intelligence conducted into the CIA detention and interrogation policies and practices. The identification should at a minimum identify and name victims and survivors, perpetrators and their collaborators. The United States also needs to conduct adequate and effective investigations into all components of the CIA torture program, and in appropriate cases, prosecute persons involved, including senior US officials who authorized and approved renditions, detention and torture, and others that knowingly assisted in carrying out the torture program. However, I think given the current political climate, I don't really hold out much hope of such an investigation taking place anytime soon. But in the meantime, the United States should consider making amends to victims and survivors, and they can do that without prosecutions. The United States, or some other body perhaps, needs to establish a mechanism for them to obtain full reparations, including acknowledgement, apologies, restitution, rehabilitation, and compensation, in a way that doesn't re-traumatize them, causing them to relive the severe pain and suffering that they once endured at the hands of their torturers, and that many are still scarred by to this day. So thank you, and I'm happy to take questions.
Thank you. Thank you for all that you've done. That's very inspiring for many of us. And I can't imagine how it would have been like to be the counsel for these men. Given the fact that over the past 2 days we've heard that oftentimes they're not allowed to even talk about their physical ailments or what caused them or et cetera in order to be able to get proper treatment. They're not allowed to go into a lot of the detail necessary to make the reparations, I think, that are necessary. How can we go around the red tape that surrounds these cases in general so that we can adequately...
I think you're perhaps referring to persons that are still detained. And
so those restrictions are not, they're not...
Yeah, no,
okay.
our clients, none of them are under any restriction to talk about what happened to them.
Okay.
I mean, the state secrets privilege, which I briefly discussed, would prevent that in the cases that you mentioned, but
okay.
not in regards to Suleiman, Mohammed, and Obaidullah and the others.
But in the case of, for example, Mohamedou, who we heard yesterday, he mentioned to us that he's not allowed to go into some of the details. Could you explain maybe a little bit about?
I think the attorney for Mohamedou's attorneys would have to explain that,
okay.
But I think it's probably because he's probably subject to certain restrictions. I know that he's subject to certain restrictions about where he can move.
Okay.
None of my clients were subject to any restrictions such as that.
Okay, so they do vary in terms
yes,
of
it
restrictions
does. It'll depend on what the terms of their release is, but none of the men that I've represented have ever been subject to any such restrictions.
Okay, thank you.
Mr. Watt, I have a question. Do you know of any plans, either by the ACLU or CCR or any other organization, to bring additional cases on behalf of men who were subjected to rendition and detention and torture by the United States?
I don't know of any currently, but based upon the decisions in the Salim litigation, as I mentioned, the door is open to certain detainees that are named in the Senate torture report to bring similar such cases against the two defendants in that case, Mitchell and Jessen. But I don't know of any currently.
Thank you.
Commissioner Cook.
Thank you, Steve. That was very informative. Without commenting specifically on the settlement, I wonder if you could give us a sense from your perspective of having represented individuals like this, of what you think the needs are in terms of, but not this specific case, but like in general, what sort of, as a lawyer, what kinds of things are on your list in terms of the kind of support or reparations that people should be thinking about, regardless of whether they are able to have their day in court?
Suleiman, Mohammed, and Obaidullah, their needs were identical. When I first met them, their needs were identical to the needs of Meher Arar, who I met way back in 2004, Canadian citizen, identical to Khaled El Masri's. The need is for acknowledgement of what happened to them. That is first and foremost what they want, and all of my clients got involved in the litigation because they saw it as a process of getting that acknowledgement. Without that acknowledgement, there's an inability for them to get on with their lives. That's what I've experienced, and it was very moving for me when I met with Suleiman, Mohammed, and Obaidullah, and I provided them with copies of the Senate torture report in which they were named. All of them wanted copies of that because that was the acknowledgement. That was official acknowledgement that they wanted. The litigation as well, that was what it was about. It wasn't about compensation. It was about acknowledgement. It was about apologies for the wrongs that happened to them. They all made that clear. It's across cultural divides, acknowledgement, apology, and I think all of them deserve compensation. I think that's so clear to me, that they need money to get on with their lives too. they were held without the possibility of earning any money. They had their lives turned upside down. You'll have heard from Dr. Porterfield yesterday. Suleiman and Mohammed both suffer from extreme PTSD and major depression. It's very difficult for them to hold down jobs and to get treatment. That's the other request that I've had time and again, is treatment, rehabilitation. And for many of these men, it's very difficult to get. Suleiman in Zanzibar, there's a doctor flown in there a couple of times to see him to do some intensive PTSD treatment. But for the others, they've just not been as fortunate, and that's a real need.
I have a question for you as well. As I know you know, in the Obama administration, there was a big shift, or at least a reported shift, with respect to the use of state secrets and a new policy that was adopted. And I'm wondering, from your perspective as a litigator, whether that made any difference in your cases, if that in some way was responsible for allowing the Mitchell and Jensen case to go forward. And relatedly, what, if you could, with a magic pen, rewrite legal doctrine in 2 to 3 ways that would facilitate your ability to bring these cases, what would you change?
Yeah. Well, actually, the Obama administration wasn't, when they first took office, we'd filed the Jeppesen litigation in the waning days of the Bush administration. And we on appeal, when we went up to appeal to the Ninth Circuit, the Obama administration had taken over, and lawyers took exactly the same position as the Bush administration. But as time went, that said, and they litigated that tough and hard with us and really took the same extreme positions on what the state secrets privilege meant in civil litigation. That being said, Holder did pass policy which changed somewhat, but it was policy. And then there was the situation in the Salim litigation. We filed in the waning days of the Obama administration, just before Trump took office. And I think it was the Senate torture report that was the game changer for us with the Obama administration. They couldn't really, with a straight face, say that the very subject matter of our client's case, their torture in a CIA prison, was a state secret. So that was the game changer. That said, the Trump administration did invoke the state secrets privilege late in the game, during the discovery process. But the government invoked it over a very limited subset of the evidence. It was a proper invocation, to be quite honest. It was over the depositions of two senior CIA operatives, and the presiding judge, upheld the state secrets privilege, but didn't dismiss the case because it was unnecessary to do so, because defendants could still mount a valid defense. But so we still think there's a place for the state secrets privilege. It's just how it's invoked, and how it was invoked, in Jeppesen and El-Masri, to dismiss an entire lawsuit without any production of evidence, just seems ridiculous.
Commissioner Goldsmith.
You have pointed out that the declassified executive summary of the Senate Select Intelligence Committee report omits any examination of the rendition component of the CIA's program. I'm wondering if you have some thoughts for the Commission as to how we might best fill that gap, particularly with specific recommendations, findings, to whom we might give the report, any action that you could suggest that the Commission might pursue to fill that gap.
Yeah, I think it would be to put together, there is a lot, Sam will have given you all the information yesterday. There is a lot of public information out there. It might not be information that has been confirmed or admitted by the US government, but it's putting that information together and I think Sam's already done that for you in a very comprehensive fashion, backing it up, corroborating it with as many separate sources as you can. And then I think you have a very detailed report of the rendition component of the CIA torture program, which was omitted in the Senate Select Committee on Intelligence report.
Thank you.
I have a question from an audience member as well about what follow-up strategy will the ACLU and other organizations that you work with pursue following the settlement of the Salim case?
With the three clients, or more broadly?
The question appears to be talking about more broadly. Both, or you could answer both.
So our next step on the accountability push. I mean, I think, as I sort of recommended, I think this notion of setting up some kind of mechanism to provide more comprehensive, holistic redress for survivors of the program, still pushing for the prosecutions at the same time, but we're not, as I mentioned earlier, we're not planning any more litigation following up on Salim, but I think it's still keeping an eye on the on U.S. accountability for torture and being persistent. I think that's one of the qualities that you have to have as the Stop Torture Now coalition folks know, in order to prevail in the accountability push.
Please join me in thanking Mr. Watts.